Okay, so magandang paano ba to? Ayan. Magandang hapon sa inyo, no? Andito na naman ang inyong Lolo Ray para magbasa-basa na naman ng mga batas, no? At subukan natin itong ipaliwanag in layman's term, no? So itutuloy natin yung pagbabasa natin about sa mercantile law, 'di ba? Commercial law, no? At under that is yung subject na corporation, kung saan binabasa natin yung corporation code. So, nandito na tayo sa Title 10 of the Corporation Code, which is pinamagatang appraisal right, at magsisimula tayo sa Section 81, no? Instances of appraisal right. Any stockholder of a corporation shall have the right to dissent o kumontra and demand payment of the fair value of his shares in the following instances. Okay, number 1, in case any amendment to the Articles of Incorporation has the effect of changing or restricting the rights of any stockholder or class of shares, or of authorizing preferences in any respect superior to those of outstanding shares of any class, or of extending or shortening the term of corporate existence. So, pwedeng kumontra doon yung stockholder at i-exercise niya yung kanyang appraisal right, no? Sabi lang dito, kapag mayroong pagbabago sa articles ng incorporation na magkakaroon ng epekto sa karapatan ng stockholder o sa karapatan ng mga holders ng mga iba't ibang uri or class ng mga shares, ganyan, pwede niyang i-exercise ang kanyang appraisal right. Number 2, in case of sale, lease, exchange, transfer, mortgage, pledge, or other disposition of all or substantially all of the corporate property and assets as provided in the code. And number 3, in case of merger or consolidation. Yan, nabasa natin siya, nagdaan nating babasahin yung merger or consolidation, di ba? Okay. Tungo na tayo sa Section 82, how right is exercised. Paano ba ginagawa ito? The appraisal right may be exercised by any stockholder who shall have voted against the proposed corporate action by making a written demand on the corporation within 30 days after the date on which the vote was taken for payment of the fair value of his shares. So, kung merong proposed corporate action, yung kumukontra na stockholder, pwede siyang gumawa ng written demand sa loob ng 30 days matapos yung pagkakabuo ng proposed action na yon, para bayaran siya sa tamang halaga o yung fair value of his shares, provided that failure to make the demand within such period shall be deemed a waiver of the appraisal right. Okay? If the proposed corporate action is implemented or affected, the corporation shall pay to such stockholder upon surrender of the certificate or certificates of stock representing his shares the fair value thereof as of the day prior to the date on which the vote was taken, excluding any appreciation or depreciation in anticipation of such corporate action. So dapat bayaran siya sa tamang halaga ng kanyang shares. Hindi kasama doon yung ine-expect na pagtaas ng halaga o pagbaba ng halaga ng shares. If within a period of 60 days from the date the corporate action was approved by the stockholders, the withdrawing stockholder and the corporation cannot agree, hindi sila magkasundo on the fair value of the shares, it shall be determined and appraised by 3 disinterested persons, tatlong walang kinalaman doon na tao. Ang isa daw doon, one of whom shall be named by the stockholder, another by the corporation, and the third by the two thus chosen. Okay? So may manok na sarili niya, yung withdrawing stockholder, meron sarili nilang manok o may sariling taga value yung corporation. Tapos may isa pang pangatlong tao na pipiliin ng disinterested stockholder and ng corporation mismo. The findings of the majority of the appraisers shall be final and their award shall be paid by the corporation within 30 days after such award is made, provided that no payment shall be made to any dissenting stockholder unless the corporation has unrestricted retained earnings in its books to cover such payment, and provided further that upon payment by the corporation of the agreed or awarded price, the stockholder shall forthwith transfer his shares to the corporation. Meron akong question dito. Paano kapag yung corporation ay merong hindi sapat yung kanilang unrestricted retained earnings para i-cover yung pagbabayad na yun? Paano kaya? Problema yun. Di ba natatandaan natin sa unrestricted retained earnings din kinukuha yung dividendo ng mga stockholders, di ba? Section 83, Effect of Demand and Termination of Right. From the time of demand for payment of the fair value of a stockholder's shares until either the abandonment of the corporate action involved or the purchase of said shares by the corporation, all rights accruing to such shares, including voting and dividend rights, shall be suspended in accordance with the provisions of this code, except the right of such stockholder to receive payment of the fair value thereof. So, uunahin nila syempre itong si dissenting stockholder, provided that if the dissenting stockholder is not paid the value of his shares within 30 days after the award, his voting and dividend rights shall be immediately restored. So, mananatili ang kanyang kapangyarihan, ang kanyang dividend rights. Kung hindi maibibigay sa kanila sa kanya ng korporasyon yung award o yung fair value payment para sa kanyang stocks sa loob ng 30 araw. Section 84, when right to payment ceases, kailan naman nawawala yung karapatan mong mabayaran? No demand for payment under this title may be withdrawn unless the corporation consents thereto. If, however, such demand for payment is withdrawn with the consent of the corporation, or if the proposed corporate action is abandoned or rescinded by the corporation, or disapproved by the Securities and Exchange Commission, where such approval is necessary, or if the Securities and Exchange Commission determines that such stockholder is not entitled to the appraisal right, then the right of said stockholder to be paid the fair value of his shares shall cease, his status as a stockholder shall thereupon be restored, and all dividend distributions which would have accrued on his shares shall be paid to him. Okay? Section 85, who bears costs of appraisal? The costs and expenses of appraisal shall be borne by the corporation unless the fair value ascertained by the appraisers is approximately the same as the price which the corporation may have offered to pay the stockholder, in which case they shall be borne by the latter. So kapag naman daw malapit ang offer ng korporasyon doon sa appraisal, ang gagastos nun ay ang stockholder na kumukontra, yung dissenting stockholder. Pero kapag malayo yung appraisal value ng shares value ng stocks kesa doon sa ino-offer ng korporasyon, korporasyon ang magbabayad. So as a general rule, korporasyon ang magbabayad. Unless after nung appraisal, makita na, oh, ganyan din yung ino-offer namin sa iyo, so ikaw magbabayad. Section 86, Notation on Certificates, Rights of Transferee. Within 10 days after demanding payment for his shares, a dissenting stockholder shall submit the certificates of stock representing his shares to the corporation for notation thereon that such shares are dissenting shares. Mga share ng kumukontra. His failure to do so shall, at the option of the corporation, terminate his rights under this title. If shares represented by the certificates bearing such notation are transferred and the certificates consequently cancelled, the rights of the transferor as a dissenting stockholder under this title shall cease, and the transferee shall have all the rights of a regular stockholder, and all dividend distributions which would have accrued on such shares shall be paid to the transferee. Okay, magtungo na tayo rito sa Title 11. Ano naman ang non-stock corporations? I-discuss niya yung mga non-stock corporations. Section 87, for the purposes of this code, a non-stock corporation is one where no part of its income is distributable as dividends to its members, trustees, or officers, subject to the provisions of this code on dissolution, provided that any profit which a non-stock corporation may obtain as an incident to its operations shall, whenever necessary or proper, be used for the furtherance of the purpose or purposes for which the corporation was organized, subject to the provisions of this title. The provisions governing stock corporation, when pertinent, shall be applicable to non-stock corporations, except as may be covered by specific provisions of this title. Okay. So, ang non-stock corporation daw ay ang isang korporasyon na walang bahagi sa kinikita nila ang pwedeng ipamahagi bilang dividendo sa kanilang mga members, trustees, or officers. Section 88, Purposes. Non-stock corporations may be formed or organized for charitable, religious, educational, professional, cultural, fraternal, literary, scientific, social, civil service, or similar purposes like trade, industry, agricultural, and like chambers, or any combination thereof, subject to the special provisions of this title governing particular classes of non-stock corporations. Chapter 1 ng non-stock corporations, yung members. Section 89, Right to Vote. The right of the members of any class or classes to vote may be limited, broadened, or denied to the extent specified in the Articles of Incorporation or the bylaws. Unless so limited, broadened, or denied, each member, regardless of class, shall be entitled to one vote. Unless otherwise provided in the Articles of Incorporation or the bylaws, a member may vote by proxy in accordance with the provisions of this code. Voting by mail or other similar means by members of non-stock corporations may be authorized by the bylaws of non-stock corporations with the approval of and under such conditions which may be prescribed by the SEC o ng Securities and Exchange Commission. Section 19, Non-transferability of membership. Membership in a non-stock corporation and all rights arising therefrom are personal and non-transferable unless the Articles of Incorporation or the bylaws otherwise provide. Section 91, Termination of membership. Membership shall be terminated in the manner and for the causes provided in the Articles of Incorporation or the bylaws. So dito ano siya, bylaws ang magdidikta usually kapag non-stock corporation. Sabagay, ganun din naman pag stock corporation, pero yung non-transferability ng membership, pag nakasaad sa bylaws na pwede mong i-transfer ang membership, pwede yun. Yung pagboto, pwede by mail o siguro sa panahon ngayon, electronic mail kapag pinayagan and under the rules ng Securities and Exchange Commission. So, termination of membership, Section 91. Membership shall be terminated in the manner and for the causes provided in the Articles of Incorporation or the bylaws. Ganun pa rin. Mangangasiwa pa rin yung bylaws. Termination of membership shall have the effect of extinguishing all rights of a member in the corporation or in its property unless otherwise provided in the articles of incorporation or bylaws. Tungo na tayo sa Chapter 2, Trustees and Officers. Section 92, Election and Term of Trustees. Unless otherwise provided in the articles of incorporation or the bylaws, the Board of Trustees of non-stock corporations, which may be more than 15 in number as may be fixed in their articles of incorporation or bylaws, shall, as soon as organized, so classify themselves that the term of office of one-third of their number shall expire every year, and subsequent elections of trustees comprising one-third of the Board of Trustees shall be held annually, and trustees so elected shall have a term of 3 years. Okay, 3 taon pala ang term ng Board of Trustees dito at pwedeng higit pa sa 15 ang members. Okay? Trustees thereafter elected to fill vacancies occurring before the expiration of a particular term shall hold office only for the unexpired period. No person shall be elected as trustee unless he is a member of the corporation. Unless otherwise provided in the articles of incorporation or the bylaws, officers of a non-stock corporation may be directly elected by the members. Section 93, Place of Meetings. The bylaws may provide that the members of a non-stock corporation may hold their regular or special meetings at any place, even outside the place where the principal office of the corporation is located, provided that proper notice is sent to all members indicating the date, time, and place of the meeting, and provided further that the place of meeting shall be within the Philippines. Magtungo na tayo sa Chapter 3, Distribution of Assets in Non-Stock Corporations. Section 94, Rules of Distribution. In case dissolution of a non-stock corporation in accordance with the provisions of this code, its assets shall be applied and distributed as follows. So, ibig sabihin doon, i-distribute lang yung assets ng non-stock corporation kapag sila in case of dissolution lamang. So, number 1, all liabilities and obligations of the corporation shall be paid, satisfied, and discharged, or adequate provision shall be made thereof. Number 2, assets held by the corporation upon a condition requiring return, transfer, or conveyance, and which condition occurs by reason of the dissolution shall be returned, transferred, or conveyed in accordance with such requirements. Number 3, assets received and held by the corporation subject to limitations permitting their use only for charitable, religious, benevolent, educational, or similar purposes, but not held upon a condition requiring return, transfer, or conveyance by reason of the dissolution, shall be transferred or conveyed to one or more corporations, societies, or organizations engaged in activities in the Philippines substantially similar to those of the dissolving corporation according to a plan of distribution adopted pursuant to this chapter. Number 4, assets other than those mentioned in the preceding paragraphs, if any, o kung meron man, shall be distributed in accordance with the provisions of the Articles of Incorporation or the bylaws to the extent that the Articles of Incorporation or the bylaws determine the distributive rights of members or any class or classes of members or provide for distribution. And number 5, in any other case, assets may be distributed to such persons, societies, organizations, or corporations, whether or not organized for profit, as may be specified in a plan of distribution adopted pursuant to this chapter. Okay? So yun ang rules of distribution ng non-stock corporations. Section 95, Plan of Distribution of Assets. A plan providing for the distribution of assets not inconsistent with the provisions of this title may be adopted by a non-stock corporation in the process of dissolution in the following manner. The Board of Trustees shall, by majority vote, adopt a resolution recommending a plan of distribution and directing the submission thereof to a vote at a regular or special meeting of members having voting rights. Written notice setting forth the proposed plan of distribution or a summary thereof and the date, time, and place of such meeting shall be given to each member entitled to vote within the time and in the manner provided in this code for the giving of notice of meetings to members. Such plan of distribution shall be adopted upon approval of at least two-thirds of the members having voting rights present or represented by proxy at such meeting. Doon na tayo sa Title 7, Closed Corporations. Ano naman ito mga to? Section 96, Definition and Applicability of the Title. A closed corporation within the meaning of this code is one whose articles of incorporation provide that, number 1, all the corporations issued stock of all classes, exclusive of treasury shares, shall be held of record by not more than that, a specified number of persons not exceeding 20. Uy, okay. So yung kanilang lahat ng uri na kanilang stock ay panghahawakan ng mga tao, specified number of persons na hindi lalagpas sa 20. Okay? Wait lang, sandali lang. Wait lang. Okay. Nahulog naman to si B. Okay. Number 2, all the issued stock of all classes shall be subject to one or more specified restrictions on transfer permitted by this title. And number 3, the corporation shall not list in any stock exchange or make any public offering of any of its stock of any class. Notwithstanding the foregoing, a corporation shall not be deemed a closed corporation when at least two-thirds of its voting stock or voting rights is owned or controlled by another corporation, which is not a closed corporation within the meaning of this code. Any corporation may be incorporated as a closed corporation except mining except mining or oil companies, stock exchanges, banks, insurance companies, public utilities, educational institutions, and corporations declared to be vested with public interest in accordance with the provisions of this code. The provisions of this title shall primarily govern closed corporations, provided that the provisions of other titles of this code shall apply suppletorily except insofar as this title provides otherwise. So, tignan nga natin, suriin natin siya. Closed corporation daw, lahat daw ng kanilang issued stock maliban sa treasury shares shall be held on record by not more than a specified number of persons na hindi lalagpas sa 20. Okay? Pangalawa, lahat ng issued stock sa lahat ng klase, maliban nga lamang siguro sa treasury shares, shall be subject to one or more specified restrictions on transfer. So, meron siyang restriction sa pagta-transfer. Hindi pwedeng basta-basta ilipat. Number 3, the corporation shall not list in any stock exchange or make any public offering of any of its stock of any class. So, yun ang ibig sabihin ng close. Parang sila-sila lang. Lahat daw ng corporation ay pwedeng maging i-incorporate as ganito, maliban na lang sa mga minahan, oil companies, schools, educational institutions, o yung mga sinasabing with public interest. Okay, so yun ang closed corporation. Medyo naunawaan na natin. Ako, pagkaintindi ko rito, sila-sila lang. Parang sila lang. Section 97, Articles of Incorporation. The articles of incorporation of a closed corporation may provide, ito yung nakalagay sa articles of incorporation nila, number 1, for a classification of shares or rights and the qualifications for owning or holding the same and restrictions on their transfers as may be stated therein, subject to the provisions of the following section. Number 2, for a classification of directors into one or more classes, each of whom may be voted for and elected solely by a particular class of stock. Number 3, for a greater quorum or voting requirements in meetings of stockholders or directors than those provided in this code. The articles of incorporation of a closed corporation may provide that the business of the corporation shall be managed by the stockholders of the corporation rather than by a board of directors, so long as this provision continues in effect. Number 1, no meeting of stockholders need be called to elect directors. Yun pala. Yun ang kaibahan nila doon sa stock corporation. Stock corporation din naman sila, pero yun sa normal na korporasyon. Di na kailangan magpatawag ng meeting para sa eleksyon ng board of directors. Number 2, unless the context clearly requires otherwise, the stockholders of the corporation shall be deemed to be directors for the purpose of applying the provisions of this code. Number 3, the stockholders of the corporation shall be subject to all liabilities of directors. So, pag ikaw pala stockholder ng isang closed corporation, matik, director ka na. The articles of incorporation may likewise provide that all officers or employees, or that specified officers or employees shall be elected or appointed by the stockholders instead of by the board of directors. Tungo na tayo Section 98, validity of restrictions on transfer of shares. Restrictions on the right to transfer shares must appear in the articles of incorporation and in the bylaws, as well as in the certificate of stock. Otherwise, the same shall not be binding on any purchaser thereof in good faith. Said restriction shall not be more onerous than granting the existing stockholders or the corporation the option to purchase the shares of the transferring stockholder with such reasonable terms, conditions, or periods stated therein. If upon the expiration of said period, the existing stockholders or the corporation fails to exercise the option to purchase, the transferring stockholder may sell his shares to any third person. Okay. So, kailangan nakalagay sa articles of incorporation nila, kung isa kang closed corporation, yung karapatan to transfer shares of stock. Okay. Kung hindi nakalagay sa articles of incorporation at sa bylaws, hindi siya pwedeng bili, hindi ka pwedeng magbenta, sa madaling salita, hindi siya magiging binding on any purchaser. Itong mga restriction na to shall not be more onerous than granting the existing stockholders of the corporation the option to purchase. So, kailangan merong option itong mga ibang kasamahan mo stockholder na bilhin yung stock mo. Parang mas gusto nila sa kanila mo ibenta kaysa sa mga tagalabas. Pero kapag nag-expire na yung period na sinasabi rito, yung existing stockholders or the corporation hindi nila binili. Hindi nila in-exercise yung kanilang option to purchase. Doon pa lang masasabi na pwedeng i-transfer nung itong transferring stockholder, pwede niya nang ibenta yung shares niya sa ibang tao. Section 99, effects of issuance or transfer of stock in breach of qualifying conditions. Number 1, if a stock of a closed corporation is issued or transferred to any person who is not entitled under any provision of the articles of incorporation to be a holder of record of its stock, and if the certificate of such stock conspicuously shows the qualifications of the persons entitled to be holders of record thereof, such person is conclusively presumed to have notice of the fact of his ineligibility to be a stockholder. Number 2, if the articles of incorporation of a closed corporation states the number of persons not exceeding 20 who are entitled to be holders of record of its stock, and if the certificate for such stock conspicuously states such number, and if the issuance or transfer of stock to any person would cause the stock to be held by more than such number of persons, the person to whom such stock is issued or transferred is conclusively presumed to have notice of this fact. Number 3, if a stock certificate of any closed corporation conspicuously shows a restriction on transfer of stock of the corporation, the transferee of the stock is conclusively presumed to have notice of the fact, that he has acquired stock in violation of the restriction if such acquisition violates the restriction. Number 4, whenever any person to whom stock of a closed corporation has been issued or transferred uh, has or is conclusively presumed under this section to have notice either letter A, that he is person not eligible to be a holder of stock of the corporation, or B, that transfer of stock to him would cause the stock of the corporation to be held by more than the number of persons permitted by its articles of incorporation to hold stock of the corporation, or letter C, that the transfer of stock is in violation of a restriction on transfer of stock. The corporation may, at its option, refuse to register the transfer of stock in the name of the transferee. Number 5, the provisions of subsection 4 shall not be applicable if the transfer of stock, though contrary to subsections 1, 2 of 3, has been consented o pinayagan naman by all the stockholders of the closed corporation, or if the closed corporation has amended its articles of incorporation in accordance with this title. Number 6, the term transfer as used in this section is not limited to a transfer for value. Number 7, the provisions of this section shall not impair any right which the transferee may have to rescind the transfer or to recover under any applicable warranty, express or implied. Okay. Tungo na tayo sa section 100. Agreements by stockholders. Number 1, agreements by and among stockholders executed before the formation and organization of a closed corporation, signed by all stockholders, shall survive the incorporation of such corporation and shall continue to be valid and binding between and among such stockholders if such be their intent, to the extent that such agreements are not inconsistent with the articles of incorporation, irrespective of where the provisions of such agreements are contained, except those required by this title to be embodied in said articles of incorporation. Number 2, okay, an agreement between 2 or more stockholders, if in writing and signed by the parties thereto, may provide that in exercising any voting rights, the shares held by them shall be voted as therein provided, or as they may agree, or as determined in accordance with the procedure agreed upon by them. Number 3, no provision in any written agreement signed by the stockholders relating to any phase of the corporate affairs shall be invalidated as between the parties on the ground that its effect is to make them partners among themselves. Okay, number 4. A written agreement among some or all of the stockholders in a closed corporation. Asan ako? Ayan. Shall not be invalidated on the ground that it so relates to the conduct of the business and affairs of the corporation as to restrict or interfere with the discretion or powers of the board of directors, provided that such agreement shall impose on the stockholders who are parties thereto the liabilities for managerial acts imposed by this code on directors. At number 5, okay, sandali lang. Tungo tayo sa number 5. To the extent that the stockholders are actively engaged in the management or operation of the business and affairs of a closed corporation, the stockholders shall be held to strict fiduciary duties to each other and among themselves. Said stockholders shall be personally liable for corporate torts unless the corporation has obtained reasonably adequate liability insurance. Tungo na tayo section 101, when board meeting is unnecessary or improperly held. Unless the bylaws provide otherwise, any action by the directors of a closed corporation without a meeting shall nevertheless be deemed valid. Okay, kahit walang meeting, valid itong gawain ng mga direktor ng closed corporation if, number 1, before or after such action is taken, written consent thereto is signed by all the directors. Number 2, all the stockholders have actual or implied knowledge of the action and make no prompt objection thereto in writing. Number 3, the directors are accustomed to take informal action with the express or implied acquiescence of all stockholders. Or number 4, all the directors have expressed or implied knowledge of the action in question and none of them makes prompt objection thereto in writing. If a directors meeting is held without proper call or notice, an action taken therein within the corporate powers is deemed ratified by a director who failed to attend unless he promptly files his written objection with the secretary of the corporation after having knowledge thereof. So pinakamaganda pala kung mag-o-object ka, written yung objection mo. Okay? Saan na ako? Ano ba yan? Hirap talagang pindutin. Okay, section 102. Preemptive right in closed corporations. The preemptive right of stockholders in closed corporations shall extend to all stock to be issued, including reissuance of treasury shares, whether for money, property, or personal services, or in payment of corporate debts unless the articles of incorporation provide otherwise. Section 103, Amendment of Articles of Incorporation. Any amendment to the Articles of Incorporation which seeks to delete or remove any provision required by this title to be contained in the Articles of Incorporation, or to reduce a quorum or voting requirements stated in said Articles of Incorporation shall not be valid, or it shall not be effective unless approved by the affirmative vote of at least 2/3 of the outstanding capital stock, whether with or without voting rights, or of such greater proportion of shares as may be specifically provided in the Articles of Incorporation for amending, deleting, or removing any of the aforesaid provisions at a meeting duly called for the purpose. Section 104, Deadlocks. Notwithstanding any contrary provision in the Articles of Incorporation or bylaws or agreement of stockholders of a closed corporation, if the directors or stockholders are so divided respecting the management of the corporation's business and affairs that the votes required for any corporate action cannot be obtained, with the consequence that the business and affairs of the corporation can no longer be conducted to the advantage of the stockholders generally, the Securities and Exchange Commission, upon written petition by any stockholder, shall have the power to arbitrate the dispute. Ang mag-arbitrate pala ang SEC, di ba? In the exercise of such power, the Commission shall have authority to make such order as it deems appropriate, including an order, number 1, canceling or altering any provision contained in the Articles of Incorporation, bylaws, or any stockholders' agreement. Number 2, canceling, altering, or enjoining any resolution or act of the corporation or its board of directors, stockholders, or officers. Number 3, directing or prohibiting any act of the corporation or its board of directors, stockholders, officers, or other persons party to the action. Number 4, requiring the purchase at their fair value of shares of any stockholder, either by the corporation regardless of the availability of unrestricted retained earnings in its books, or by the other stockholders. Number 5, appointing a provisional director. Number 6, dissolving the corporation. Or number 7, granting such other relief as the circumstances may warrant. Okay? Ganito pala mangyayari pag deadlock, parang hati-hati daw ang pananaw ng directors or stockholders sa pagmamanage ng corporation, no? Aabot pa dun sa punto na papagitna ang SEC. A provisional director shall be an impartial person who is neither a stockholder nor a creditor of the corporation or of any subsidiary or affiliate of the corporation, and whose further qualifications, if any, may be determined by the Commission. Magdedetermine yan yung Commission, Securities and Exchange Commission. So similar ito doon sa sa parang administrator, 'di ba? Kumbari may minor children, hindi pa nila mapakasiwaan yung ari-ari ang naiwan sa kanila, ang korte ay magtatalaga ng administrator. Parang ganun siya. A provisional director is not a receiver of the corporation and does not have the title and powers of a custodian or receiver. Similar lang siya doon, parang a provisional director daw, yun nga nabanggit na wala naman siyang interest talaga doon sa corporation, shall have all the rights and powers of a duly elected director of the corporation, including the right to notice of and to vote at meetings of directors until such time as he shall be removed by order of the commission or by all the stockholders. His compensation shall be determined by agreement between him and the corporation subject to approval of the commission, which may fix his compensation in the absence of agreement or in the event of disagreement between the provisional director and the corporation. Section 105, withdrawal of stockholder or dissolution of corporation. Closed corporation pa rin yung pinag-uusapan natin dito ha. In addition and without prejudice to other rights and remedies available to a stockholder under this title, any stockholder of a closed corporation may, for any reason, compel the said corporation to purchase his shares at their fair value, which shall not be less than their par or issued value, when the corporation has sufficient assets in its books to cover its debts and liabilities exclusive of capital stock. Provided that any stockholder of a closed corporation may, by written petition to the SEC or Securities and Exchange Commission, compel the dissolution of such corporation whenever any of acts of the directors, officers, or those in control of the corporation is illegal or fraudulent or dishonest or oppressive or unfairly prejudicial to the corporation or any stockholder, or whenever corporate assets are being misapplied or wasted. Pwede raw sumulat, no? Yung isang stockholder, di ba? Magpe-petition siya, written petition to the SEC para i-compel ang dissolution ng korporasyon. Dahil nagkakaletse-letse na lang parang ganun yung punto niya. Title 13, Special Corporations, Section 106. Magpunta muna tayo Chapter 1 ng Title 3, Educational Corporation, Section 106, Incorporation. Educational corporation shall be governed by special laws and by the general provisions of this code. Section 107, Prerequisites to Incorporation. Except upon favorable recommendation of the Ministry of Education and Culture, the SEC shall not accept or approve the articles of incorporation and bylaws of any educational institution. Ang masakit lang nito sa tunay na buhay, kapag ka malakas ka sa pamunuan ng Department of Ministry of Education pa nakasaad dito, at bibigyan kanila ng recommendation sa palakasan na lang din Malakas ka rin sa SEC kunwari. Section 108, Board of Trustees. Trustees of educational institutions organized as non-stock corporations shall not be less than 5 nor more than 15, provided however that the number of trustees shall be in multiples of 5, unless otherwise provided in the articles of incorporation, on the bylaws, or the bylaws to on yung nakalagay. The Board of Trustees of incorporated schools, colleges, or other institutions of learning shall, as soon as organized, so classify themselves that the term of office of 1/5 of their number shall expire every year. Trustees thereafter elected to fill vacancies occurring before the expiration of a particular term shall hold office only for the unexpired period. Trustees elected thereafter to fill vacancies caused by expiration of term shall hold office for 5 years. Okay, yun ang kanilang period. A majority of the trustees shall constitute a quorum for the transaction of business. The powers and authority of trustees shall be defined in the bylaws. For institutions organized as stock corporations, the number and term of directors shall be governed by the provisions on stock corporations. Punta naman tayo sa Chapter 2, pangalawang chapter ng Special Corporations. Religious corporations naman. Section 109, Classes of Religious Corporations. Religious corporations may be incorporated by one or more persons. Pag religious, pwedeng isa lang, no? Okay. Pwedeng si Kibuloy lang, no? One or more persons, yan, no? Such corporations may be classified into corporations sole and religious societies. Religious corporations shall be governed by this chapter and by the general provisions of non-stock corporations insofar as they may be applicable. Magtungo naman tayo sa Section 110, Corporation Sole. For the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church, a corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of such religious denomination, sect, or church. Okay? So Section 111, Articles of Incorporation. In order to become a corporation sole, the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church must file with the Securities and Exchange Commission articles of incorporation setting forth the following. So ito yung dapat nakalagay. Kung magtatayo ako ng iglesia ni John John, kunwari, no? Number 1, that he is the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of his religious denomination, sect, or church, and that he desires to become a corporation sole. Number 2, that the rules, regulations, and discipline of his religious denomination, sect, or church are not inconsistent with his becoming a corporation sole and do not forbid it. Number 3, that as such chief archbishop, bishop, priest, minister, rabbi, or presiding elder, he is charged with the administration of the temporalities and the management of the affairs, estate, and properties of his religious denomination, sect, or church within his territorial jurisdiction, describing such territorial jurisdiction. Number 4, the manner in which any vacancy occurring in the office of chief archbishop, bishop, priest, minister, rabbi, or presiding elder is required to be filled according to the rules, regulations, or discipline of the religious denomination, sect, or church to which he belongs. And number 5, the place where the principal office of the corporation sole is to be established and located, which place must be within the Philippines. The articles of incorporation may include any other provision not contrary to law for the regulation of the affairs of the corporation. Section 112, Submission of the Articles of Incorporation. The articles of incorporation must be verified before filing by affidavit or affirmation of the chief archbishop, bishop, priest, minister, rabbi, or presiding elder as the case may be, and accompanied by a copy of the commission, certificate of election, or letter of appointment of such chief archbishop, bishop, priest, minister, rabbi, or presiding elder, duly certified to be correct by any notary public. So ipapanotaryo mo. From and after the filing with the Securities and Exchange Commission of the said articles of incorporation, verified by affidavit or affirmation, and accompanied by the documents mentioned in the preceding paragraph, such chief archbishop, bishop, priest, minister, rabbi, or presiding elder shall become a corporation sole, and all temporalities, estate, and properties of the religious denomination, sect, or church theretofore administered or managed by him as such chief archbishop, bishop, priest, minister, rabbi, or presiding elder shall be held in trust by him as a corporation sole for the use, purpose, behalf, and sole benefit of his religious denomination, sect, or church, including hospitals, schools, colleges, orphan asylums, parsonages, and cemeteries thereof. Okay. Section 113, Acquisition and Alienation of Property. Any corporation sole may purchase and hold real estate and personal property for its church, charitable, benevolent, or educational purposes, and may receive bequests or gifts for such purposes. Such corporation may sell or mortgage real property held by it by obtaining an order for that purpose from the court of first instance of the province where the property is situated upon proof made to the satisfaction of the court that notice of the application for leave to sell or mortgage has been given by publication or otherwise in such manner and for such time as said court may have directed, and that it is to the interest of the corporation that leave to sell or mortgage should be granted. The application for leave to sell or mortgage must be made by petition, duly verified by the chief archbishop, bishop, priest, minister, rabbi, or presiding elder acting as corporation sole, and may be opposed by any member of the religious denomination, sect, or church represented by the corporation sole, provided that in cases where the rules, regulations, and discipline of the religious denomination, sect, or church, religious society, or order concerned represented by such corporation sole regulate the method of acquiring, holding, selling, and mortgaging real estate and personal property. Such rules, regulations, and discipline shall control, and the intervention of the court shall not be necessary. So, ano po yun ito yung pagka magbebenta, kunwari magsasala ng property ang corporation sole na itinatag para sa religious charitable purpose, kailangan siya maghingi ng order sa court at kailangan niya masatisfy yung court na ang pagsasanla o ang kanyang pagbebenta ng ari-arian ng simbahan o ng corporation sole ay makabubuti para sa kapakanan ng corporation na yun. Section 114, filling of vacancies. The successors in office of any chief archbishop, bishop, priest, minister, rabbi, or presiding elder in a corporation sole shall become the corporation sole on their accession to office and shall be permitted to transact business as such on the filing with the Securities and Exchange Commission of a copy of their commission, certificate of election, or letters of appointment duly certified by any notary public. During any vacancy in the office of chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church incorporated as a corporation sole, the person or persons authorized and empowered by the rules, regulations, or discipline of the religious denomination, sect, or church represented by the corporation sole to administer the temporalities and manage the affairs, estate, and properties of the corporation sole during the vacancy shall exercise all the powers and authority of the corporation sole during such vacancy. Section 115, dissolution. A corporation sole may be dissolved and its affairs settled voluntarily by submitting to the Securities and Exchange Commission a verified declaration of dissolution. Ito yung nakalagay sa verified declaration of dissolution. Number 1, the name of the corporation. Number 2, the reason for dissolution and winding up. Number 3, the authorization for the dissolution of the corporation by the particular religious denomination, sect, or church. Number 4, the names and addresses of the persons who are to supervise the winding up of the affairs of the corporation. Upon approval of such declaration of dissolution by the Securities and Exchange Commission, the corporation shall cease to carry on its operations except for the purpose of winding up its affairs. Okay. Para lang malaman natin, di ba? Yung dissolution, madi-dissolve na yung kumpanya. Pero pwede pa rin daw nilang ituloy to carry out their operations during their winding up. So hanapin natin yung ibig sabihin ng winding up. Yan, para lang alam nating mga kalayman yung ibig sabihin ng winding up. Sabi rito sa Investopedia, winding up is the process of dissolving a company. While winding up, a company ceases to do business as usual. Tumitigil siya sa kanyang pagnenegosyo, yung normal business. Its sole purpose is to sell off stock, okay, benta ng stocks, pay off creditors, bayad ng mga utang, and distribute any remaining assets to partners or shareholders. The term is used primarily in Great Britain, where it is synonymous with liquidation, which is the process of converting assets to cash. Okay. So, mas naintindihan na natin yung winding up. Section 116, Religious Societies. Sabi rito, any religious society or religious order or any diocese, synod, or district organization of any religious denomination, sect, or church, unless forbidden by the Constitution, rules, regulations, or discipline of the religious denomination, sect, or church of which it is a part, or by competent authority may, upon written consent and or by an affirmative vote at a meeting called for the purpose of at least two-thirds of its membership, incorporate for the administration of its temporalities or for the management of its affairs, properties, and estate by filing with the SEC articles of incorporation verified by the affidavit of the presiding elder, secretary, or clerk, or other member of such religious society or religious order or diocese, synod, or district organization of the religious denomination, sect, or church, setting forth the following. So ito yung ilalagay nila. Number 1, that the religious society or religious order or diocese, synod, or district organization is a religious organization of a religious denomination, sect, or church. Number 2, that at least two-thirds of its membership have given the written consent or have voted to incorporate at a duly convened meeting of the body. Number 3, that the incorporation of the religious society or religious order or diocese, synod, or district organization desiring to incorporate is not forbidden by competent authority or by the Constitution, rules, regulations, or discipline of the religious denomination, sect, or church of which it forms a part. Number 4, that the religious society or religious order or diocese, synod, or district organization desires to incorporate for the administration of its affairs, properties, and estate. Number 5, the place where the principal office of the corporation is to be established and located, which place must be within the Philippines. And number 6, the names, nationalities, and residences of the trustees elected by the religious society or religious order or the diocese, synod, or district organization to serve for the first year or such other period as may be prescribed by the laws of the religious society or religious order or of the diocese, synod, or district organization, the board of trustees, to be not less than 5, no more than 15. Okay. Magtungo na tayo sa Title 14, Dissolution. Ako, mahaba-haba itong dissolution. Okay, Section 117, Methods of Dissolution. A corporation formed or organized under the provisions of this code may be dissolved voluntarily or involuntarily. Pag-usapan natin yung Section 118, Voluntary Dissolution, where no creditors are affected. Walang maapektuhang pinagkakautangan. If dissolution of a corporation does not prejudice the rights of any creditor having a claim against it, the dissolution may be effected by a majority vote of the board of directors or trustees and by a resolution duly adopted by the affirmative vote of the stockholders owning at least two-thirds of the outstanding capital stock or of at least two-thirds of the members of a meeting to be held upon call of the directors or trustees after publication of the notice of time, place, and object of the place for 3 consecutive weeks in newspaper published in the place where the principal office of said corporation is located. So, kailangan ipapublish mo ito. Kailangan ipublish mo na magdi-dissolve ka na. Usually, ang purpose ng dissolution is to inform kung maaari everyone para yung mga pinagkakautangan makasingil na o makakome forward na. And if no newspaper is published in such place, then in a newspaper of general circulation in the Philippines, after sending such notice to each stockholder or member, either by registered mail or by personal delivery at least 30 days prior to said meeting. A copy of the resolution authorizing the dissolution shall be certified by a majority of the board of directors or trustees and countersigned by the secretary of the corporation. The SEC shall thereupon issue the certificate of dissolution. Article 119. Okay, bago tayo magtungo dyan, Dissolution pa rin tayo, papahinga lang ako at iihi. Diyan lamang. Okay, ako'y nagbabalik. Nandito pa rin tayo sa dissolution, no? Yung una kanina, nabanggit natin yung pag walang creditors na affected, no? Walang pinagkakautangan na affected ang dissolution ng isang korporasyon. Magtungo naman tayo sa section 119, voluntary dissolution where creditors are affected. Okay? Where the dissolution of a corporation may prejudice the rights of any creditor, the petition for dissolution shall be filed with the Securities and Exchange Commission. The petition shall, idedirekta mo pala, no? The petition shall be signed by a majority of its board of directors or trustees or other officers having the management of its affairs, verified by its president or secretary, or one of its directors or trustees, and shall set forth all claims and demands against it, and that its dissolution was resolved upon by the affirmative vote of the stockholders representing at least two-thirds of the outstanding capital stock, or by at least two-thirds of the members at a meeting of its stockholders or members called for that purpose. If the petition is sufficient in form and substance, the Commission shall, by an order reciting the purpose of the petition, fix a date on or before which objections thereto may be filed by any person, which date shall not be less than 30 days nor more than 60 days after the entry of the order. Before such date, a copy of the order shall be published at least once a week for 3 consecutive weeks in a newspaper of general circulation published in the municipality or city where the principal office of the corporation is situated, or if there be no such newspaper, then in a newspaper of general circulation in the Philippines, and a similar copy shall be posted for 3 consecutive weeks in 3 public places in such municipality or city. Upon 5 days' notice given after the date on which the right to file objections as fixed in the order has expired, okay, meron palang 5 days notice doon para mag-object, no? The Commission shall proceed to hear the petition and try any issue made by the objections filed. If no such objection is sufficient and the material allegations of the petition are true, it shall render judgment dissolving the corporation and directing such disposition of its assets as justice requires, and may appoint a receiver to collect such assets and pay the debts of the corporation. Section 120, dissolution by shortening corporate term. A voluntary dissolution may be effected by amending the articles of incorporation to shorten the corporate term pursuant to the provisions of this code. A copy of the amended articles of incorporation shall be submitted to the Securities and Exchange Commission in accordance with this code. Upon approval of the amended articles of incorporation of the expiration of the shortened term, as the case may be, the corporation shall be deemed dissolved without any further proceedings, subject to the provisions of this code on liquidation. Section 121, involuntary dissolution. A corporation may be dissolved by the Securities and Exchange Commission upon filing of a verified complaint and after proper notice and hearing on the grounds provided by existing laws, rules, and regulations. Section 122, corporate liquidation. Every corporation whose charter expires by its own limitation or is annulled by forfeiture or otherwise, or whose corporate existence for other purposes is terminated in any other manner, shall nevertheless be continued as a body corporate for 3 years after the time when it would have been so dissolved, for the purpose of prosecuting and defending suits by or against it, and enabling it to settle and close its affairs, to dispose of and convey its property, and to distribute its assets, but not for the purpose of continuing the business for which it was established. At any time during said 3 years, the corporation is authorized and empowered to convey all of its property to trustees for the benefit of stockholders, members, creditors, and other persons in interest. From and after any such conveyance by the corporation of its property in trust for the benefit of its stockholders, members, creditors, and others in interest, all interest which the corporation had in the property terminates the legal interest, vests in the trustees, and the beneficial interest in the stockholders, members, creditors, or other persons in interest. Upon the winding up of the corporate affairs, any asset distributable to any creditor, stockholder, or member who is unknown or cannot be found shall be escheated to the city or municipality where such assets are located. So magiging subject siya ng escheat proceedings. Yun yung proceedings kung saan mapupunta sa city or municipality yung kanyang ari-arian. Except by decrease of capital stock and as otherwise allowed by this code, no corporation shall distribute any of its assets or property except upon lawful dissolution and after payment of all its debts and liabilities. Tungo na tayo sa Title 15, Foreign Corporations. Section 123, Definition and Rights of Foreign Corporations. For the purposes of this code, a foreign corporation is one formed, organized, or existing under any laws other than those of the Philippines and whose laws allows Filipino citizens and corporations to do business in its own country or state. It shall have the right to transact business in the Philippines after it shall have obtained the license to transact business in this country in accordance with this code and a certificate of authority from the appropriate government agency. Okay, no? So itong foreign corporations na to, ito yung nabuo sa batas ng kanilang sariling bansa, hindi sa batas natin. Tapos pinapayagan nilang makipag-transact ang mga Pilipino, ang mga Filipino corporations or citizens sa kanila. Okay? So pwede rin sila mag-transact sa atin kasi pinapayagan nila tayo eh. Pero kailangan muna nilang manguha ng license to transact, di ba? Siguro kukunin nila to sa SEC, no? And certificate of authority from the appropriate government agency. Baka sa SEC na nila kukunin pareho ito. Section 124, siguro, hindi siguro sa SEC pareho. Kung may kinalaman sa trade, baka sa DOTR, ganyan, kukuha sila ng ng certificate of authority. Section 124, application to existing foreign corporations. Every foreign corporation which on the date of effectivity of this code is authorized to do business in the Philippines under a license therefore issued to it shall continue to have such authority under the terms and conditions of its license subject to the provisions of this code and other special laws. Section 125, application for a license. A foreign corporation applying for a license to transact business in the Philippines shall submit to the SEC a copy of its articles of incorporation and bylaws certified in accordance with law and their translation to an official language of the Philippines. Kung kailangan, the application shall be under oath and unless already stated in its articles of incorporation shall specify set forth the following. So kung hindi pa ito nakalagay sa kanilang articles of incorporation, sasabihin nila, ilalagay nila itong date and term of incorporation. Number 2, the address, including the street number of the principal office of the corporation in the country or state of incorporation. Number 3, the name and address of its resident agent authorized to accept summons and process in all legal proceedings and pending the establishment of a local office all notices affecting the corporation. Number 4, the place in the Philippines where the corporation intends to operate. Number 5, the specific purpose or purposes which the corporation intends to pursue in the transaction of its business in the Philippines, provided the said purpose or purposes are those specifically stated in the certificate of authority issued by the appropriate government agency. Number 6, the names and addresses of the present directors and officers of the corporation. Number 7, a statement of its authorized capital stock and the aggregate number of shares which the corporation has authority to issue, itemized by classes, par value of shares, shares without par value, and series, if any. Number 8, a statement of its outstanding capital stock and the aggregate number of shares which the corporation has issued, itemized by classes, par value of shares, shares without par value, and series, if any. Number 9, a statement of the amount actually paid in. And number 10, such additional information as may be necessary or appropriate in order to enable the Securities and Exchange Commission to determine whether such corporation is entitled to a license to transact business in the Philippines and to determine and assess the fees payable. Attached to the application for license shall be a duly executed certificate under oath by the authorized official or officials of the jurisdiction of its incorporation, attesting to the fact that the laws of the country or state of the applicant allow Filipino citizens and corporations to do business therein, and that the applicant is an existing corporation in good standing. If such certificate is in a foreign language, a translation thereof in English under oath of the translator shall be attached thereto. The application for a license to transact business in the Philippines shall likewise be accompanied by a statement under oath of the President or any other person authorized by the corporation, showing to the satisfaction of the Securities and Exchange Commission and other governmental agency in the proper cases that the applicant is solvent and in sound financial condition, and setting forth the assets and liabilities of the corporation as of the date not exceeding 1 year immediately prior to the filing of the application. Foreign banking, financial, and insurance corporations shall, in addition to the above requirements, comply with the provisions of existing laws applicable to them. In the case of all other foreign corporations, no application for license to transact business in the Philippines shall be accepted by the Securities and Exchange Commission without previous authority from the appropriate government agency whenever required by law. Section 126, Issuance of a License. If the Securities and Exchange Commission is satisfied that the applicant has complied with all the requirements of this code and other special laws, rules, and regulations, the Commission shall issue a license to the applicant to transact business in the Philippines for the purpose or purposes specified in such license. Upon issuance of the license, such foreign corporation may commence to transact business in the Philippines and continue to do so for as long as it retains its authority to act as a corporation under the laws of the country or state of its incorporation, unless such license is sooner surrendered, revoked, suspended, or annulled in accordance with this code or other special laws. Within 60 days after the issuance of the license to transact business in the Philippines, the license, except foreign banking or insurance corporation, shall deposit with the SEC for the benefit of present and future creditors of the licensee in the Philippines. Magde-deposit sila ng securities satisfactory to the SEC, okay, consisting of bonds or other evidence of indebtedness of the government of the Philippines, its political subdivisions and instrumentalities, or of government-owned or controlled corporations and entities, shares of stock in registered enterprises, as this term is defined in RA 5186, shares of stock in domestic corporations registered in the stock exchange, or shares of stock in domestic insurance companies and banks, or any combination of these kinds of securities with an actual market value of at least 100,000 pesos, provided, however, that within 6 months after each fiscal year of the licensee, the SEC shall require the licensee to deposit additional securities equivalent in actual market value to 2% of the amount by which the licensee's gross income for that fiscal year exceeds 5 million pesos. Okay? So, kung kumikita sila ng 5 million pesos, Dito sa Pilipinas, dapat 2% nun. Karagdagang security nila sa SEC. The Securities and Exchange Commission shall also require deposit of additional securities if the actual market value of the securities on deposit has decreased by at least 10% of their actual market value at the time they were deposited. The SEC may at its own discretion release part of the additional securities deposited with it if the gross income of the licensee has decreased or if the actual market value of the total securities on deposit has increased by more than 10% of the actual market value of the securities at the time they were deposited. Yun yung parang tumaas na yung halaga o bumaba na yung halaga ng previous deposit nila. The Securities and Exchange Commission may from time to time allow the licensee to substitute other securities for those already on deposit as long as the licensee is solvent. Hindi po yung tumitira ng solvent ha, ito yung ibig sabihin may kapasidad magbayad, may pera. Such licensee shall be entitled to collect the interest or dividends on the securities deposited. In the event the licensee ceases to do business in the Philippines, the securities deposited as aforesaid shall be returned upon the licensee's application therefor, and upon proof to the satisfaction of the SEC that the licensee has no liability to Philippine residents, wala siyang atraso rito sa Philippine residents, including the government of the Republic of the Philippines. Haba. Section 127, who may be a resident agent? A resident agent may either be an individual residing in the Philippines or a domestic corporation lawfully transacting business in the Philippines, provided that in the case of an individual, he must be of good moral character and of sound financial standing. Mahaba na naman to. Section 128, Resident Agent Service of Process. The SEC shall require as a condition precedent to the issuance of the license to transact business in the Philippines by any foreign corporation that such corporation file with the SEC a written power of attorney designating some person who must be a resident of the Philippines on whom any summons and other legal processes may be served in all actions or other legal proceedings against such corporation, and consenting that service upon such resident agent shall be admitted and held as valid as if served upon the duly authorized officers of the foreign corporation at its home office. Okay, parang yung resident agent nila dapat Pilipino na nananirahan dito, at dapat pag sinerban mo yun ng summons, it is as if yung mismong foreign corporation ang sinerban mo. Kasi mahirapan tayo mag-serve ng summons sa abroad. Any such foreign corporation shall likewise execute and file with the SEC an agreement or stipulation executed by the proper authorities of said corporation in form and substance as follows. So ganito daw. The American Express Corporation, name of foreign corporation does hereby stipulate and agree in consideration of its being granted by the SEC a license to transact business in the Philippines, that if at any time said corporation shall cease to transact business in the Philippines or shall be without any resident agents in the Philippines on whom any summons or other legal process may be served, then in any action or proceeding arising out of any business or transaction which occurred in the Philippines, service of any summons or other legal process may be made upon the Securities and Exchange Commission, pwede daw sa SEC i-serve, and that such service shall have the same force and effect as if made upon the duly authorized officers of the corporation at his home office. So dapat daw ganon. Whenever such service of summons or other processes shall be made upon the SEC, the Commission shall, within 10 days thereafter, transmit by mail a copy of such summons or other legal process to the corporation at its home or principal office. The sending of such copy by the Commission shall be necessary part of and shall complete such service. All expenses incurred by the Commission for such service shall be paid in advance by the party at whose instance the service is made. In case of a change of address of the resident agent, it shall be his or its duty to immediately notify in writing the SEC of the new address. Ay, mag-break muna tayo. Mamaos na ako. Okay, ako yung nagbabalik. Dito pa rin tayo sa foreign corporations, no? Sila pa rin yung pinag-uusapan natin. Section 129, Law Applicable. Any foreign corporation lawfully doing business in the Philippines shall be bound by all laws, rules, and regulations applicable to domestic corporations of the same class, except such only as provide for the creation, formation, organization, or dissolution of corporations, or those which fix the relations, liabilities, responsibilities, or duties of stockholders, members, or officers of corporations to each other or to the corporation. Section 130, Amendments to Articles of Incorporation or Bylaws of Foreign Corporations. Whenever the Articles of Incorporation or Bylaws of a foreign corporation authorized to transact business in the Philippines are amended, such foreign corporation shall, within 60 days after the amendment becomes effective, file with the Securities and Exchange Commission and in the proper cases with the appropriate government agency a duly authenticated copy of the Articles of Incorporation or Bylaws as amended, indicating clearly in capital letters or by underscoring the change or changes made, duly certified by the authorized official or officials of the country or state of incorporation. The filing thereof shall not of itself enlarge or alter the purpose or purposes for which such corporation is authorized to transact business in the Philippines. Article 131, Amended License. A foreign corporation authorized to transact business in the Philippines shall obtain an amended license. In the event it changes its corporate name or desires to pursue in the Philippines other or additional purposes by submitting an application therefore to the SEC, favorably endorsed by the appropriate government agency in proper cases. Section 132, Merger or consolidation involving a foreign corporation licensed in the Philippines. One or more foreign corporations authorized to transact business in the Philippines may merge or consolidate with any domestic corporation or corporations if such is permitted under Philippine laws and by the law of its incorporation, provided that the requirements on merger or consolidation as provided in this code are followed. Whenever a foreign corporation authorized to transact business in the Philippines shall be a party to a merger or consolidation in its home country or state as permitted by law of its incorporation, such foreign corporation shall within 60 days after such merger or consolidation becomes effective, file with the SEC and in proper cases with the appropriate government agency a copy of the Articles of Merger or Consolidation, duly authenticated by the proper official or officials of the country or state, under the laws of which merger or consolidation was effected. Provided, however, that if the absorbed corporation is the foreign corporation doing business in the Philippines, the latter shall at the same time file a petition for withdrawal of its license in accordance with its title. Okay? Kung yung nagkaroon ng merger sa bansa nila, ang na-absorb yung nakikipag-transact sa atin dito. So wala na siya. 'Di ba? So kunwari ang example natin Pepsi, Coca-Cola, na-absorb kunwari ng Coca-Cola yung Pepsi. Pepsi yung ka-transact natin dito. Etong bagong korporasyon na to, they shall file a petition for withdrawal of its license in accordance with this title. Ang tingin ko noon kung gusto pa rin ng bagong merge, kung gusto pa rin ng bagong company na mag-transact ng negosyo rito, dadaan ulit sila sa bagong proseso na mag-secure ng license to transact dito sa Pilipinas. Section 133, Doing Business Without a License. No foreign corporation transacting business in the Philippines without a license or its successors or assigns shall be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency in the Philippines, but such corporation may be sued or proceeded against before Philippine courts or administrative tribunals on any valid cause of action recognized under the Philippine laws. Okay, sandali lamang ha, at magsisend lang tayo ng ating YouTube channel. Diba? Dali lang. Yan. Okay. Okay, Section 134, Revocation of License. Without prejudice to other grounds provided by special laws, the license of a foreign corporation to transact business in the Philippines may be revoked or suspended by the SEC upon any of the following grounds. Okay, number 1, failure to file its annual report or pay any fees as required by this code. Number 2, failure to appoint and maintain a resident agent in the Philippines as required by this title. Number 3, failure after change of its resident agent or of his address to submit to the SEC a statement of such change as required by this title. Number 4, failure to submit to the SEC an authenticated copy of any amendment to its articles of incorporation or bylaws or of any articles of merger or consolidation within the time prescribed by this title. Number 5, a misrepresentation of any material matter in any application, report, affidavit, or other document submitted by such corporation pursuant to this title. Number 6, failure to pay any and all taxes, imposts, assessments, or penalties, kung meron man, lawfully due to the Philippine government or any of its agencies or political subdivisions. Number 7, transacting business in the Philippines outside of the purpose or purposes for which such corporation is authorized under its license. Number 8, transacting business in the Philippines as agent of or acting for and in behalf of any foreign corporation or entity not duly licensed to do business in the Philippines. Or number 9, any other ground as would render it unfit to transact business in the Philippines. Section 135, issuance of certificate of revocation. Upon the revocation of any such license to transact business in the Philippines, the SEC shall issue a corresponding certificate of revocation, furnishing a copy thereof to the appropriate government agency in the proper cases. The SEC shall also mail to the corporation at its registered office in the Philippines a notice of such revocation accompanied by a copy of the certificate of revocation. Section 136, withdrawal of foreign corporations. Subject to existing laws and regulations of a foreign corporation licensed to transact business in the Philippines may be allowed to withdraw from the Philippines. So yung mga may lisensya raw na foreign corporation to transact business dito, pwede silang payagan mag-withdraw from the Philippines by filing a petition for withdrawal of license. No certificate of withdrawal shall be issued by the SEC unless all the following requirements are met. Number 1, all claims which have accrued in the Philippines have been paid, compromised, or settled. Wala na silang atraso rito. Number 2, all taxes, imposts, assessments, and penalties, if any, lawfully due to the Philippine government or any of its agencies or political subdivisions have been paid. Again, wala nang atraso. And number 3, the petition for withdrawal of license has been published once a week for 3 consecutive weeks in a newspaper of general circulation in the Philippines. Okay, magtungo na tayo sa Title 16. Ang tingin ko, ito na yung last na title. Ito yung miscellaneous provisions. Pero mahalaga to para marami tayong maintindihan. Section 137, outstanding capital stock defined. Ano yung ibig sabihin? Kasi dito sa buong corporation code, madalas nating naririnig yung 2/3 of the owners of the outstanding capital stock. Diba? Parang sila yung masusunod diba? The term outstanding capital stock as used in this code means that total shares of stock issued under binding subscription agreements to subscribers or stockholders, whether or not fully or partially paid, except treasury shares. Section 138, designation of governing boards. the provisions of specific provisions of this code. To the contrary, notwithstanding, non-stock or special corporations may, through their articles of incorporation or their bylaws, designate their governing boards by any name other than as Board of Trustees. Section 139, Incorporation and other fees. The SEC is hereby authorized to collect and receive fees as authorized by law or by rules and regulations promulgated by the Commission. Section 140, Stock ownership in certain corporations. Okay, papaliwanag niya to. Sabi rito, pursuant to the duties specified in Article 14 of the Constitution, the National Economic and Development Authority, the NEDA, from time to time, make a determination of whether the corporate vehicle has been used by any corporation or by business or industry to frustrate the provisions thereof or of applicable laws, and shall submit to the Batasang Pambansa, whenever deemed necessary, a report of its findings, including recommendations for their prevention or correction. So yung NEDA pala ay inoobliga na para bagang mag-imbestiga, tignan nila kung ginagamit lamang ba ng masasamang tao ang isang korporasyon para makagawa ng mga kalokohan. At ang mga report na ito ay isusumite sa Batasang Pambansa, di ba? Ang tingin ko para at magbibigay sila ng recommendations. Pag-aaralan ito ng Kongreso para makagawa siguro ng karampatang batas para pigilan yung paglalaro ng ilang makapangyarihang tao at ginagamit ang korporasyon para sa masama. Maximum limits may be set by the Batasang Pambansa for stock holdings in corporations declared by it to be vested with the public interest pursuant to the provisions of this section, belonging to individuals or groups of individuals related to each other by consanguinity or affinity or by close business interests, or whenever it is necessary to achieve national objectives, prevent illegal monopolies or combinations in restraint or trade, or to implement national economic policies declared in laws, rules, and regulations designed to promote the general welfare and foster economic development. In recommending to the Batasang Pambansa corporations, business or industries to be declared vested with public interest, ito yung mga nababanggit kadalasan na mining, oil, educational institutions, yan. And in formulating proposals for limitations on stock ownership, the NEDA o National Economic Development Authority shall consider the type and nature of the industry, the size of the enterprise, the economies of scale, the geographic location, the extent of Filipino ownership, the labor intensity of the activity, the export potential, as well as other factors which are germane to the realization and promotion of business industry. Section 141. Ano ba ito? May langaw. Dali lang, nababother ako sa langaw na to. Annual report of corporations. So every corporation, domestic or foreign, lawfully doing business in the Philippines shall submit to the SEC, Securities and Exchange Commission, an annual report of its operations together with a financial statement of its assets and liabilities certified by any independent certified public accountant in appropriate cases, covering the preceding fiscal year and such other requirements as the SEC may require. Such reports shall be submitted within such period as may be prescribed by the Securities and Exchange Commission. Section 142. Confidential nature of examination results. All interrogatories propounded by the SEC and the answers thereto, as well as the results of any examination made by the Commission or by any other official authorized by law to make an examination of the operations, books, and records of any corporation shall be kept strictly confidential, except insofar as the law may require the same to be made public, or where such interrogatories, answers, or results are necessary to be presented as evidence before any court. Section 143, Rulemaking power of the SEC. Ito. ang talagang nangangasiwa sa korporasyon ay yung Securities and Exchange Commission. The SEC shall have the power and authority to implement the provisions of this code and to promulgate rules and regulations reasonably necessary to enable it to perform its duties hereunder, particularly in the prevention of fraud and abuses on the part of the controlling stockholders, members, directors, trustees, or officers. Section 144, Violations of the Code. Violations of any of the provisions of this code or its amendments not otherwise specifically penalized therein shall be punished by a fine of not less than 1,000 pesos, hindi bababa sa 1,000, but not more than 10,000 pesos. Baka mas mataas na ito ngayon, hindi ako sure. Or by imprisonment for not less than 30 days, but not more than 5 years, or both in the discretion of the court. If the violation is committed by a corporation, the same way after notice and hearing, be dissolved in appropriate proceedings before the SEC, provided that such dissolution shall not preclude the institution of appropriate action against the director, trustee, or officer of the corporation responsible for said violation. Provided further that nothing in this section shall be construed to repeal the other causes for dissolution of a corporation provided in this code. Ay, malapit na tayo matapos, Section 145, Amendment or Repeal. No right or remedy in favor of or against any corporation, its stockholders, members, directors, trustees, or officers, nor any liability incurred by any such corporation, stockholders, members, directors, trustees, or officers shall be removed. Okay, walang yung mga liability nila hindi maaaring mawala or impaired either by the subsequent dissolution of said corporation or by any subsequent amendment or repeal of this code or of any part thereof. So kahit na mabago pa yung code, may mabagong provision dito. O kahit pa ma-dissolve na yung korporasyon, yung mga obligasyon pa rin ng korporasyon at ng mga stockholder nito ay mananatili. Section 146. Ibig sabihin nun, yung mga utang, atraso, yan. Hindi sila makakapagtago sa pamamagitan ng pagdidissolve ng korporasyon. Section 146, Repealing Clause. Except as expressly provided in this code, all laws or parts thereof inconsistent with any provision of this code shall be deemed repealed. Okay? Section 147, Separability of Provisions. Should any provision of this code or any part thereof be declared invalid or unconstitutional, the other provisions, so far as they are separable, shall remain in force. Sabi niya. Okay. Sabi lamang dito yung mga karagdagang provision. Section 148, Applicability to existing corporations. So sabi niya, all corporations lawfully existing and doing business in the Philippines on the date of effectivity of this code. Na-approve itong code na to May 1, 1980. And doing business in the Philippines on the date of the effectivity of this code and here to authorized, licensed, or registered by the SEC shall be deemed to have been authorized, licensed, or registered under the provisions of this code, subject to the terms and conditions of its license, and shall be governed by the provisions hereof, provided that if any such corporation is affected by the new requirements of this code, said corporation shall, unless otherwise herein provided, be given a period of not more than 2 years from the effectivity of this code within which to comply with the same. Okay, so yung mga naapektuhan noong 1980, kunwari na-approve ito 1980, so sabihin na natin, alam ko may publication pa ito, sabihin na natin 1980 pa rin, may 2 taon pa siya yung mga naapektuhan ng corporation code para mag-adjust at makapag-comply sila sa nakalagay dito. Section 149, Effectivity. This code shall take effect immediately upon its approval. Okay. So hanggang 149, no? Hanggang Section 149. So doon po natin natatapos ang ating corporation code. Napakahirap. Okay. Basahin, lalo pat unawain, no? Pero bago tayo magtapos, magdasal muna tayo. Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. In the name of the Father, the Son, the Holy Spirit. Amen. So maraming salamat sa mga sumama sa akin. At sana po ay lagi niyo akong samahan sa aking pagbabasa. At susubukan natin ipaliwanag ito ang mga batas. Susubukan natin ipaliwanag in layman's term. Sumuli ito si Lolo Ray. God bless at paalam.